Hey, welcome to another installment. This is My ATL Law. It's Slipikoff and Slumka. I'm Adam Slipikoff,
I'm Howard Slumka.
and we like to record these questions and answer sessions for our clients so that people can see these. Now, we have a careful legal disclaimer up front that we do not have an attorney-client relationship just by virtue of these posts, but we do encourage you to meet with us, see if we can help with your situation, and we'd be happy to have you as a client. So here's a question that we get a lot, and this actually was written into us. So, Howie, I'm going to ask you this question.
Okay.
If I don't pay the balloon payments on a second home equity line of credit, and a lot of people have an equity line to tap into that equity as a source of cash flow. Now, if that balloon payment was included but not reaffirmed in a Chapter 7, okay, will the lenders foreclose? Now, I want to explain one more time. So for folks, this is somebody who went through a bankruptcy, but this was not reaffirmed, meaning help people understand first what a reaffirmation is when they've gone through bankruptcy.
So when you file a bankruptcy, some people will come to us and say, well, I don't want to file bankruptcy on this debt or on that debt, or I want to keep my house or keep my car out of it. And you can't do that. When you file bankruptcy, you disclose all of your assets and you must disclose all of your debts. And there's a very simple reason for that. Everybody would want to pay their Aunt Sally, and nobody wants to pay Bank of America. So guess who has better lobbyists in DC?
Aunt Sally?
Not Aunt Sally.
Right.
So the banks win, and you need to put everybody and treat them all equally. So what happens when you have a home equity line of credit? If you're our client, and if you're thinking in advance, you make a very careful determination of whether you want to reaffirm the debt or not reaffirm the debt. Now, what reaffirming a debt means is that you like the debt and you like the asset that collateralizes it, in this case your home, and you want to keep it and you want to pay it and you want to pretend that it was never in the bankruptcy. It's a waiver. It's a document that says, even though I filed bankruptcy, I like this debt and I will pay it till the end of time, or until it's paid off. So that's why I say it's a waiver. You don't have to sign this agreement.
Right.
If you don't sign the reaffirmation agreement, it doesn't mean you lose your house. You actually do not ever have to pay that second mortgage ever again if you don't pay it. So you would say, well, then why would anybody reaffirm a debt? And the answer is this. Their ability to sue you for money goes away after the bankruptcy, but their lien on the house does not go away. So you kind of are holding guns to each other's head. They are saying, we will foreclose on your house if you don't pay us, even though you don't have to pay us. But you're in the driver's seat because you are saying, I'm going to pay you because I want to keep my house for now. There may come a time when you don't want to keep the house. Maybe your home is underwater and you can walk away from that second loan, the second mortgage, and they cannot sue you for the $100,000 that you still owe, but they can enforce their lien against your home.
Okay, so in this case, this is someone who went through Chapter 7. Obviously, they've kept their home, and that means they kept their first mortgage, their primary mortgage. So they've stayed with that. They wanted to reaffirm it in their process, and that makes sense because maybe they had a great rate. Today, you could get 3.5%, 4% mortgages. And also, they liked that there was a lot of equity. They didn't want to move their home. So they stayed in that house. But on that second mortgage now, when they say, look, it wasn't reaffirmed. So since it wasn't reaffirmed, can they be foreclosed on?
Right.
Who has the power to foreclose? The first mortgage holder or the second?
And this is when you need the lawyer. This is a great big game of chicken. The second mortgage holder has the right to foreclose on your home, but it hurts them to do it because they are behind the first mortgage holder. Exactly. So when they foreclose, the first mortgage could wipe them out depending on what gets paid. So they don't really want to foreclose. Now they'll send you a letter that's threatening and it makes it seem like they want to foreclose, but they don't. And we negotiate these all the time. Again, this is for after the bankruptcy is over.
Right. So let's run a couple of numbers. For example, this is let's say a person who has a house worth $200,000 and the first mortgage is up to $150,000.
Right.
Now, let's say they took out a second mortgage for $30,000 and then they filed bankruptcy. So now again, the numbers, $200,000 value on when I say value, that is meaning if you put it up for listing and somebody bought it after many months of tours, then if it goes into foreclosure, if that second mortgage holder pushes them into foreclosure. On the courthouse steps, it's going to be worth a lot less.
And if somebody bids 150 on it, then the second mortgage holder, the one who wrote you the letters and who is driving you into foreclosure, is going to be kicking themselves because they're not going to get anything when that house sells for 150 and they've lost their mortgage on the property. So again, game of chicken. But the best clients will discuss this game of chicken at the time of filing. Exactly. So there's no surprises after the bankruptcy. And we deal with this all the time. We both cars and homes have to be carefully considered when you enter a bankruptcy. And there are ways to keep them and keep your debt and reaffirm your debt. And there's a time to do it. And there are very real times not to do it.
And there's also part of a conversation that your lawyer would have with the bank, the first and the second mortgage companies. You don't want any surprises. You want to tell everybody what is expected and have a cohesive plan, at least internally. You can't control what they may do, but certainly a good attorney can put you on the right path.
Right.
So, well, listen, we've enjoyed covering this question. We're going to cover more as well. Thanks so much. Continue to write in. We will try to answer as many as we can here. Email your questions at info@myatllaw, and you could reach us as well. Just ask for us or anyone at our firm. That's info@myatllaw. You could also email us, and our phone number is 678-732-0001. One more time, 678-732-0001. Any parting thoughts?
No. Come to see us sooner rather than later, so that this client, it sounds like, is getting caught after the fact with something they didn't, they hadn't pondered.
That's right. Well, we hope that you won't have many surprises after you talk with us. So we look forward to talking to you and look forward to our next installment soon. Thanks so much. Take care.
Bye-bye.